Good day. I am Troy, and today we're going to be discussing a few topics. And one of our main topics today is going to be the three paradigms of law and how it's relevant to law enforcement. Now, the three paradigms of law is basically the what we consider to be the consensus paradigm. We have the conflict paradigm and also the pluralist paradigm. To break that down for you, the consensus paradigm is the idea that most people have similar beliefs and values. Now, this basically it comes down to basic ethics, where you might believe something, and I might believe the same thing is right. Somebody else might see it as wrong, and they might have another person who might side them in terms of saying that yes, it is wrong as well. So this is what the consensus paradigm speaks about, which is basically persons just have similar beliefs, values, and goals. Because I could have one person who sides me and say, this is the correct thing to do. This is the right thing to do. Another person will say, this is the wrong thing to do. And it all boils down to law in terms of how you interpret the law. And this is something that we need to really pay attention to, because how you might view a particular sector of the law might not be how I would view it. And that's basically what it is when we refer to the consensus paradigm. Now, we also have what we refer to as the conflict paradigm, where the ideas that we would say groups in society, okay, uh, have fundamental differences. For instance, the African religion might believe that it is right, sorry, for a male to abuse his wife. However, in American society, it is different. You're not allowed to assault your wife. That is an offense. So it basically tells you that um, everybody has their belief as to how they believe things should be going. And you always get the conflict paradigm, especially with persons uh, in position of authority. For instance, the government or the persons who in positions where they could control stuff basically would believe that they would do things in their favor. So you would have the upper class against the lower class. But when it comes to law, the government will put things in place which will benefit them, not necessarily the lower class or the people at the bottom, the persons who cannot afford. So it's like, for instance, you an average person and you hiring a lawyer, but you don't have the money to hire the best lawyer. The lawyer that you hired may not give you the quality work of that of a person who might give you an extensive amount of work for your money. So guess what? You're basically getting substantial treatment or results for the money that you're paying for. And that's the problem that we have most times. Now, that goes down to the pluralist paradigm, which has the concept that there are many groups in society, and that the easiest way to break it down is that they form allegiances and correlation, right, in a dynamic power. Now, this is to say that the easiest way out is government. It all boils down to government again. So guess what? You have the government who is there for who sides with other persons to decide, you know what, this is what we're gonna do. This is how we're gonna face certain situations. This is how we're gonna end up being the upper class or the upper echelon, whilst this person remain down to the bottom. And these are the things that we need to remember every time that we think about the different paradigms in terms of how it affects law, because it's like the government versus the people. That's the simplest way in how we could put it. Now, we're going to continue by comparing the idea of our criminal law system as an adversarial system. And this basically means, in simple terms, you go to court and there are two sets of persons. You have the defense and you have the prosecution. And it's basically what it is the relationship between the two of them in terms of what are the purposes. And I'll tell you something, the purpose of the defense and the prosecution, one, the defense is to ensure that the client gets a fair trial. The prosecution also has an obligation to ensure that there is a fair trial against that defendant, but also prove that that person has done whichever offense that has been charged for. And the relationship, especially when it comes to the courthouse, um, in terms of the courtroom and how the adversary amongst the law professionals is that you have the judge who's there to mitigate and ensure that nobody crosses the line, and then you have the prosecution whose main task is to ensure that there is sufficient evidence. I remember sufficient evidence to charge or to prosecute a case, and the defense task is to ensure that the prosecution does not break any ethics, code of ethics in terms of how they would go about prosecuting a case against a defendant. And so what tends to happen, or what we believe happens most time, we think that they're basically fighting against each other, but they're not. Both of them have similar traits and similar tasks in the courts. We believe that the prosecution, the job is to ensure that the person gets charged, but no, they also have an obligation that if there is not sufficient evidence to proceed with a case, then they have the obligation of doing what, which is to decline and ask that the matter be withdrawn against a defendant. Likewise, the defense also has to ensure that, guess what, the client has a fair trial. And that's basically what it is. Now, the third point we're going to touch on, sorry about this, the third point we're going to touch on is we're going to describe how we can make the criminal law system less adversarial. And the easiest way to do this is prior to court, defense and prosecution can come together, compare notes, and figure out whether or not there is sufficient evidence to prosecute a person and so forth. If there is evidence, then everything will work. But it doesn't have to seem like they're fighting at all times. And they could always have a mitigation process. It's just like similar to what you call the plea bargain. And we now, as law professionals, have to ensure that if we're doing something right, then guess what? If somebody has committed a crime, then the correct procedures are followed and so forth, and then there's no uh, infighting and so forth. Because sometimes what appears to be happening is that you have the prosecution fighting against the defense. It is not the job of the prosecution to fight against the defense. It is the role is, one is to bring a case before the courts and to prove that an offense was committed. And defense role is to ensure that no injustice is done to the client. And I think if we use if we go for that process, then everything will be good, and it falls right back to what we refer to as the three paradigms of law. One might not agree with the other, one might agree with the other. So prior to certain situations, then we could make things happen. If the process is that a person makes a plea bargain deal because they feel like I do not want to go to prison for 25 years, then so be it. The law has provisions for that. So I think this is it. That would be the easiest way in terms of having some sort of a mitigation process where the two parties will come together and say, this is what I have, this is what your client did, X, Y, and Z, and then let the defense in return let the client know, well, this is the evidence against you, and so forth. The prosecution has enough evidence, so I suggest that you go the other route and have a plea bargain or something. That in return would cause less of the against and the for situations that we have in court in terms of the adversarial systems that we have about this one versus that one. Yes, it's the job, but sometimes we could make life so much easier by just coming together and deciding this is the right case, this is the right way. Although it still boils down to the person, the client, who's paying the money. Because yes, I might have done the wrong thing, but I don't want to go to prison. So it still boils down to them at the end of the day. Thank you.